It's not about, it's not about, it's not about the injury. It's not about, it's not about, it's not about the injury. It's about the recovery. It's about the recovery.
Hey folks, this is Paul Padda with the Paul Padda Podcast. Welcome to another episode coming to you from Red Chimp Studios. Today, I'm really honored to have Judge Susan Johnson on the podcast. Judge Johnson, I guess we should fist bump, given the social distancing that's being encouraged by all these government officials. We're in really unprecedented times. This is strange, huh?
We are.
Wow. So I want to talk a little bit about you because our guests are watching and they want to know, first of all, you're an incumbent judge and you've been on the bench for how many years now?
Over 13.
Wow, 13 years. And you're running for re-election.
I am.
And so tell us a little bit about yourself.
Well, I am a 56-year resident of Clark County. I came here in November of 1963. In fact, it was the week that JFK died. I came here with my parents. I was 4 years old. I was an attorney for 21 years, and I probably practiced in every area of the law. And I was an AV rated attorney by Martindale Hubbell. I did civil rights defense where I represented the police department. I represented our jails, Clark County. Bottom line, I was doing all these quasi-judicial things that I thought I'd just do it for real.
Yeah.
And so I ran for election in 2006, and I won, and I've been a judge since January 2007.
Now, that's amazing. You know, from my perspective as a trial attorney, I love having judges who've had that experience having litigated cases themselves. And so with 21 years experience before coming on the bench, you know what it's like to stand there on the other side arguing a motion as a judge. You know, now you're obviously on the other side. Do you ever sometimes miss being an advocate?
I do. In fact, that was probably the hardest part about the transition.
Do you sit there sometimes and say, gosh, this guy's a bozo. I could argue this better than he's doing?
And you've got to let unless it's plain error, you've got to let the mistakes happen.
Right.
But yes, there's sometimes that you almost want to save the day, but you can't.
Yes.
My job, again, is to be the umpire. I call the balls and strikes, as you just indicated.
Yeah.
And I just have to let them do their thing.
What's the biggest challenge you've seen in terms of being a judge?
Well, I have to say, sometimes being patient with lawyers that I don't think are doing quite the job that they should be doing.
Sure.
That is certainly a challenge.
Yeah.
And of course, time commitment in terms of learning how to keep your time frames up, getting your decisions out, things like that.
Right.
So,
yeah. No, I think that's really important. It's very important for a judge to be decisive. It's not whether you feel sorry for one side or the other. You just have to follow the law and make a decision.
and sometimes it's not popular. You upset 50% of the people
That's
every
right.
day.
Somebody's got to lose. That's
Right.
true. Then on top of all of that we talked about, like for example, managing a civil and criminal docket, you have something called the jury trial.
Yes.
And so this is enshrined in our Constitution. Can you tell folks out there why is jury duty so important?
Well, historically, in fact, no one really knows when jury service really began, but the thought was it came about in the English countries when William the Conqueror came about in 1066 and conquer that country.
Yeah.
And the thought was at that time that it was better to have a case heard by a jury of our peers or several people, as opposed to one cold judge.
Right.
And then it kind of evolved and came to the American colonies. And again, it was thought that it would be better to have a jury of our peers. In some respects, some thought it'd be tougher to bribe a bunch of people as opposed to one person. But anyway, it evolved, and people liked that, of course.
Yes.
And then, of course, we had jury trials available during the colonial period. And then when the Revolutionary War times were coming, that was one of the first rights that King George III wanted to take away.
Right.
And so a right to a jury trial in a criminal action was actually enshrined in Article 3 of our Constitution. And then later on, it was put into the 7th Amendment for civil cases. It was that important. In fact, it was so important that it was within the Declaration of Independence that King George was being obstreperous and trying to take away our right to a jury trial.
Yeah.
And of course, it has evolved since then. Of course, back then, you had basically rich white men that were members of our jury. Now it has evolved to where we have people of color, and we also have women. In fact, sadly, women did not have the right to serve on a jury for many, many years.
That's crazy.
It is crazy.
Yeah.
In fact, the last state to allow women to serve on a jury was in 1966.
Wow.
Yes.
Yeah, that's amazing.
It is amazing.
Well, to think, and then there's still parts of the world, obviously, women can't even drive. So
Right.
we've come a long way as a society. We have a lot further to go. And I actually, for one, just think that if we had more female judges and we had more people in the government that were women, we'd have sometimes better decisions.
Well,
we need diversity.
The good news is we do have more women on our civil criminal bench than we do men. I don't know how that happened, just by election or something, but
Yeah.
it did happen.
Yeah.
I don't know. At one point, we had actually more men than we did women on the family court bench, but I think it is pretty much equalized.
Well, we need people who are balanced on
Yes.
the bench, male or female. That's been my
Absolutely.
experience. I think that, it's good to have diversity, but it's also equally important to have people who have the right judicial temperament, who have the experience, and bring all that to bear. A lot of folks don't understand that actually it's judges that make legal decisions, and what the jury does is decide factual issues, right?
That is true.
So I have a lot of clients who sometimes will say, well, how can this be something that the judge decides? And I explain to them that, look, if it's a legal issue, it's the judge's job to apply the law and to interpret the law to make decisions that involve the law. But when it comes to an issue of fact where it's a he said, she said, or there could be two sides to the story, that's something where a jury gets involved. We have citizen peers who sit there and say, okay, well, we're going to assess the credibility of both these sides and come up with a decision. And that's what makes our country so great, because ultimately it's not, like you said, one person just making the decision.
That's right. In fact, we often say that the jurors are the judges of the facts. In fact, they're instructed on that, and that the judge is the judge of the law.
Yeah, that's right. So, when you let's explain to folks. There's something called the veneer.
Yes.
Which is before we end up with the jury. What is a veneer?
Well, first of all, we start with a pool, and that's when there are summonses sent out to everybody. Okay. Then, of course, we have people show up as a result of those jury summonses. And, of course, some people they don't need to come because maybe we had juries, trials settled, things like that. Well, the veneer comes in, and anybody who shows up, that is part of the veneer.
Okay.
And then, of the veneer, then they are divided up depending on how many trials we have, how many jurors we need for each trial. Like for a construction defect case, it's going for 9 months. Well, guess what? The last one we needed 750 jurors. In a regular civil trial, we might need 35.
Yeah.
Well, then we divide them up into panels. And then those panels go to the various courtrooms, and then they are subject to what we call voir dire, which is, what it means basically is to tell the truth.
Yeah.
We ask jurors questions bearing on their qualifications to sit as a juror.
Right.
And then they may be chosen, they may not be. They may be excused for cause. They may have a preemptory challenge, meaning that for whatever reason, the lawyer doesn't think that they would be the best juror for their case. They have so many preemptory challenges. And then ultimately, in a civil case, we will get 8 jurors with however many alternates we may need. In a criminal trial, it is 12 jurors with how many alternates we may need. And then the alternates, of course, is a very important role because they have to step into the shoes of a regular juror in case somebody gets sick or they just, for whatever reason, cannot serve.
Yeah, that's a great explanation. So, when folks get these summons in the mail, this is not something you just throw in the garbage, right?
I would not. It's not a good thing because
There
they
could be
say
consequences.
there's jury duty for a reason. They could be held criminally or be subject to fines.
Right.
So it's very important to appear. We have a right to a jury by our peers by virtue of our Constitution, which of course means we need people to serve on the jury, and it is the only civil service that we owe to our country. And I see it as an honor to serve.
Yeah.
Now, most people don't like to get those jury summonses, and I get that, but I would have to say that just about every trial that I've had jurors, even in that 9-month trial that I did, were very happy that they did serve. They thought it was a very interesting process.
I've actually talked to jurors after some trials, and I'm always amazed and blown away and impressed at how smart people are. Because sometimes as lawyers, the things that we think are so important in our trial, these juries are not even focusing on, and they're just applying common sense. And then you stop and think about it, and you're like, you know what? This actually makes I understand why they ruled the way they did, or how they found for this person, or why. And it's really amazing how people bring common sense. And that's actually a jury instruction, is that apply your common sense if you're on a jury.
Absolutely. They do not leave that at the door.
So now the whole concept of voir dire is like really to ferret out bias in part. Some lawyers
sure.
want to fight, but being biased, we're all biased. It doesn't mean if you're stricken as a juror for cause that you're a bad person or anything. It just means that the lawyers feel that you might bring something to the table. That's part of the process, is that both sides get to decide. Like, for example, perhaps if you had a family member that was a victim of a crime, you might feel very strongly about certain issues. You might not be able to look at a situation completely fairly, or you may be able to, but that's the whole point of voir dire, is to ferret out those kind of biases, correct?
Absolutely. That's exactly the reason. You're right. You may have somebody who was maybe a defendant in a case, and so they know what the process is about, and they may say, look, I don't know that I can treat the state or the prosecution fairly. I'd be more looking at the defendant and rendering a verdict for the defendant, even though they haven't even heard the case yet.
Yeah. So now, oftentimes folks they have the right to say, hey, look, Judge, this is going to be a real hardship on me. I can't serve on the jury. Explain that process and the factors that you would consider in deciding whether to discharge someone from jury duty.
Well, of course, it depends on how long the trial is going to be. It depends on what their issue is. You've got people in there that may have some medical issues that they can't sit for very long. Of course, those people I let stand up as long as they're not blocking the view of the other jurors. There may be a language impediment. Language is not a barrier, by the way, to serving on a jury. We can have an interpreter in the box.
I didn't know that.
Yes, but you may have lawyers thinking that might be a little cumbersome. Maybe that would not be the best juror to be put in there.
Especially if you have a 2-week trial.
Exactly, And if you've got a 3-week trial, 4-week trial, maybe somebody who is a sole owner of a business, that would be quite a financial crunch.
You find people sometimes just kind of making up excuses for trying to get out of jury duty.
Right.
And that happens, right? Obviously.
Sure.
And so it's your job as a judge sometimes to kind of be a little tough on those folks and explain to them the importance of why this is such a big deal. I mean, we all would like to do other things with our time sometimes, but it's almost like, if we have people who put their lives on the line to go into the military.
Right.
And I guess this is the equivalent of that from a civilian perspective, is that your society is just calling on you to come and do this thing that's so important and it's enshrined in our Constitution. So how do you deal with those people when you find that maybe they just might be making up an excuse?
Well, I just remind them that this is the only civil service that they do owe to their country. And it is not a hardship if they are having to sit there for a couple of days. If it is a 4, 5, 6 week period of time, I get it. And then you look, well, you've got a job. You're working for a utility company. You can sit here for a couple of days. And so usually what I do is I listen to all the excuses that the jurors have to make. Then I actually confer with the lawyers and say, which ones do you think should be let go for cause? And it's interesting to get their perspectives as well. And usually you get an agreement with the lawyers about who should be let go for cause.
What do you, can you give us some examples of cases that you've presided over that were just, obviously judges have to have a poker face, and you can't show too much emotion sometimes just because a jury's watching, and you don't ever want to give the impression that you favor one side or the other. But are there cases that are just so memorable in your mind, as far as either just because of the facts or the lawyering, or just maybe perhaps there were witnesses that were so compelling?
Well, I would have to say more issues. One case comes to mind that it did not actually go to trial, but it was heartbreaking. You had a gentleman who had been in jail for a year and a half.
Yeah.
He could not afford bail. He had been accused by his live-in girlfriend's minor daughter of him sexually assaulting her. And we were about ready to go to trial, and there's a statute on the books that allow a child not to have to testify, but that their information comes in through other means, like through a therapist or something like that. And so we have a hearing on that to determine whether that would be appropriate. And bottom line, the mother came in, and after her spiritual advisors had talked to the child over the course, of course, several months, had determined that bottom line, she recanted. She had said all these things, had actually gone on the internet to figure out what to say to police and what her mother, and had decided that she wanted her mommy and daddy to get back together, and the boyfriend was an impediment. And so immediately I have to thank the prosecutor. I mean, he and the police immediately went out, confirmed everything with the child, and he was in my office with a motion with a dismissal. I could not sign that thing fast enough. And sadly, as soon as he got out and was released, he did not believe his lawyer that it wasn't going to happen again, and he absconded out of the country.
Oh my gosh.
It was a very sad case, but that one is memorable to me.
I believe it, That's crazy. Those are terrible, heartbreaking facts all the way around. And of course the child was just motivated by trying to keep folks together, but sometimes,
but he was incarcerated for a year and a half.
Oh my goodness.
Yeah.
In your experience presiding over criminal cases, do you find a lot of people just kind of get caught up in the criminal justice system based upon just dumb decisions or bad circumstances in life?
Yes.
And then as a human being, you're sitting there and you're forced to, you have to apply the law, you do your job, that's part of what you have to do. But you also must, as a human being, sit there and say to yourself, this person, you have empathy for them. And how do you deal with that? Balancing what you have to do legally versus, maybe you feel sorry for a particular defendant.
Well, and the defendants I feel sorry for in that sense are the ones that have had, obviously a bad upbringing. They have had bad elements, and they get into the drug scene, and those crimes that are motivated by drugs. In fact, in my experience, about 95% of the theft crimes that have come before me were motivated by drug use. They're trying to get money for their next fix. And those are very heartbreaking. And then you also get somebody who they get together with their buds, become unknowingly the driver of the getaway car. And yes, and they are part of that robbery, that burglary, or whatever it was. And so you just have to go ahead and sentence. You take into account their criminal background, how horrible, how bad was the crimes. And you do your best to try and get them help, rehabilitate them, make terms of probation that would be appropriate. For example, have them go to drug counseling, have them go to inpatient treatment if they've got a drug problem. If they've got an alcohol problem, don't allow them to drink make that a condition of probation. Those kinds of things.
That's really important. And I think, we have such a discussion going on right now about our criminal justice system, but I think that there are so many programs out there like Hope for Prisoners.
Awesome program.
It's a great program. And I think that there is, but at the same time, there has to be some accountability. That's what I think makes being a judge so tough. And I have so much admiration for anyone that's doing it, because people like yourself who have to balance, you as a human being, you feel sorry for this person, you have to apply the law, but then hopefully you can come up with something that, where the punishment fits the crime.
I can't say enough good things about Hope for Prisoners, but because it is faith-based, we cannot make that a term of probation. We can recommend it, we can suggest it, but we cannot make it a term of probation.
Judge Johnson, it's been such a pleasure having you on today. You have an amazing background. Thank you for so many years of public service, and we're very lucky to have you as a judge in this.
Thank
you so much.
I enjoyed it. Thank you.
Folks, that's another episode of the Paul Padda Podcast. Until next time, be safe.
It's not about